Hi, I'm Rhein Zarghami, a trust and estates lawyer in our Stamford office of Cummings Lockwood. I'd like to talk to you this morning about planning for a modern family. Planning for a family that's like the Cleaver family is fairly straightforward. Some families come in and they just look just like the Cleaver family, where June Cleaver has 2 sons, and it's very straightforward planning. But sometimes planning is a little bit more complicated. This is the Kardashian-Jenner family. And you can see you need a family tree to figure out who's who and how they're related. I might mention them again, so just quickly to point out, Caitlyn Jenner has been married twice before with 2 kids from each prior marriage, and then married Chris, who was married before with 4 prior kids, and then they had 2 kids together. So that's 10 children between them. And so you have to really focus in on who should receive and at what times, and do they want to treat all 10 of these children the same? Have they combined their money? I know they're divorced now, but when they were married, did they combine their money, and do they want to use it as one pot? Or do they want to keep everything segregated and plan only for their respective descendants, including the 2 they have together? And so it gets complicated. Later in the presentation, I'll tell you a little bit about children that are born out of wedlock. Just like on the far left, we have 3 children born out of wedlock with one of the Kardashian girls, Scott Disick. So you just want to be sensitive to that and make sure your document contemplates what the true effect of your documents is, so you don't accidentally exclude beneficiaries that someone very much wants to plan for. The first slide I'll talk about at the most length, because I think this is where we can be really effective partners going forward. Some assets do not pass by will, so you spend a lot of time as estate planners drafting a document and deciding for the Kardashian-Jenner family that we want everything to go in 10 shares and only after the death of the survivor of the couple. But assets that are held jointly with right of survivorship, assets like life insurance and retirement accounts, don't pass by a will. So you have to be really sensitive to the fact that the bulk of somebody's assets may not pass pursuant to the terms of a will at all. So you have the client that comes in and says, this is my second marriage, I want everything to go to the kids of my first marriage after my spouse's death. And you say, what are your assets? And they say, a jointly owned home with my second spouse, a retirement account payable to her, and some life insurance payable to her. And you look at them and say, well, nothing will pass to your kids of the first marriage potentially. It'll all be left to your second spouse, and she will have control over those assets because of the way they pass. So you want to be sensitive to that as planners when you're opening accounts. Should these accounts be opened in the client's name or in joint names? And joint with right of survivorship passes differently than tenancy in common. Should life insurance be paid directly to the spouse? Or should they be paid to the client's will? So the terms of the will, and as those wishes evolve over time, dictate where the life insurance proceeds will be paid, are really good types of planning. You want to be mindful when somebody gets divorced that an old IRA or 401k that designates the divorced spouse as beneficiary is not revoked. So you have that laughing ex-spouse that inherits this big 401k or IRA account, and it's awful. So you, as advisors, can help and look at those beneficiary designations and make sure that the ex-spouse is not the beneficiary of these plans. Same thing for life insurance. Marital trusts sometimes get a bad rap because people think, I don't trust my spouse, so I'm going to put it into a trust. But oftentimes, after the death of a client, the surviving client is really glad to have a marital trust, because we say to them, those funds are now protected. You can use those funds, they are for your benefit, but if you get remarried, those funds are not subject to the claims of a second divorcing spouse. And they're relieved to know that the children they have of the marriage with their deceased spouse will receive those funds regardless of what claims of creditors come in. You probably see marital trusts come through for your clients. You should know that they must provide all income to the spouse, but they don't really have to provide much more than that. They can provide for principal access, but maybe that's inappropriate. They can provide a 5%, up to 5% withdrawal right in the spouse, but they don't have to. They can provide a power of appointment so that the surviving spouse can dictate where the trust funds goes at the surviving spouse's death, but they don't even have to provide a power of appointment. Those things you see pretty routinely, but careful planning may necessitate some but not all of those powers. Using the right trustee becomes critical if you do have principal invasion powers. Inheritances, this is Modern Family. Some of you are probably familiar with this show, but Jay Pritchard in the middle has a second marriage to Gloria, who is about the same age as the children of his first marriage. So when you have that situation as planners, you want to think about the fact that, is Jay going to be okay with the typical plan, which is everything to my spouse, either outright or in trust, and after my spouse's death, then property to my children, when there's a likelihood that his wife survives his 2 children from the prior marriage because they're the same age? Is he okay with Claire and Mitch receiving nothing during their lifetime? If not, you might want to think about putting a bug in your client's ear about making a bequest right at the client's death and using formulaic expressions so that you don't trigger unnecessary tax. When you have children of different marriages in this scenario, you have Jay's first 2 children from a prior marriage, and then now he lives with Gloria's son, Manny, and then they together have a little child, Joe, together. Should Jay's estate be divided into 3 shares if he doesn't want to provide for Manny because he's not a lineal descendant, or 4 if he does think of Manny as his child now? And is that fair that Claire and Mitch might have had their college and weddings paid for and had more benefit with the funds, or would you like to provide additional support for the minor children before the shares are split between 4? We've had blended families since at least 1969 in pop culture with the Brady Bunch, and so you want to be sensitive too to the fact that in blended families, when children are living together, who should be the guardian of Carol Brady's 3 girls if she passes away? Should it be Mike, or should it be Carol's sister? Should they all have the same guardian? Should they be kept together, even if it means that Mike's kids end up with Carol's sister? You want to just be thoughtful and bring up these issues to your client to make sure that you're meeting their family's needs. When you're selecting fiduciaries in these roles, is it appropriate for Greg Brady to act as executor, or is that going to create friction among the 3 sets of siblings? Should it be Marcia and Greg acting as co-fiduciaries as a representative for each side? These are things that the client probably knows, but you really do have to ask the question and probe. And sometimes you're in a unique position of knowing the family better than the trust and estates lawyers, and so you can assist with those conversations. In a family like this, it's sometimes good to think about using a neutral fiduciary, somebody who, neither sides of the family will consider biased against them. You need to now, this is really much more modern than the blended Brady family, carefully distinguish what it means to be a child. Now that we have in vitro and we have egg and sperm donors and surrogacy, a child could be born to a woman but not be any product of genetic material from that marriage. And so you want to carefully make sure that your documents, created by another firm, not Cummings Lockwood, doesn't define children as only biological children. You need to make sure that you have decided whether you want an unknown grandchild. For example, picture your own son having a child that he never knew about because nobody cared to tell him that he was a father. Would you want that grandchild to appear at the reading of your will and step in and say, I am a grandchild of my grandparent, even though nobody ever knew of me, or not? Your will can dictate whether or not that child should inherit, and so you have an opportunity to decide. If you say nothing, then state law will dictate, and typically that child will inherit. We have powers of appointment in marital trusts. They can include, when you leave a trust for your child, they can include just the children of that descendant or your own descendants, but maybe you want it broader, charities, spouses of descendants. If you have a Tony Soprano and Livy S. Soprano example where he's providing support for his mother, do you want to provide in Tony's will some measure of support for her in her lifetime so that you don't leave Carmela dealing with a mother-in-law that she doesn't care about? And is that going to reduce friction? You guys see maybe deposits coming out and expenses being paid on the behalf of elderly parents. If you see that or know about that, you might want to inform us so we know maybe there should be provisions made. Life insurance could be an effective tool because you could change beneficiaries or let the policy lapse when that elderly parent dies. Family business complications, this is the Trump family up on the screen, presents an unusual planning complication. for blended families because in the Trump family, it appears so far that only 3 of the 5 children are running the family business. Should each of the 5 children therefore get an equal share of the business eventually, or should it only be the children running the business? What will you do for the other children if you don't provide an equal share of the business? What will you do for the second spouse who's reliant on that business to provide a measure of support? And planning for the unknown. Oftentimes you have a Cleaver family coming in, and at the next generation, you have a more complicated family. So even though some of these things sound outlandish right now for a particular family scenario, you do want to contemplate it in your documents so that you're able to adjust. You could have an at-risk child that was just 2 years old at the drafting of the will that's now needs more protection. So you want to have the proper powers in your trust.